We can begin.
Okay, ma'am. So, ma'am, shall I begin? I'll first introduce you.
Yes, please.
Okay, so hello, good morning, everybody. Welcome to the session on how to draft a divorce petition by mutual consent. So today's resource person is Mrs. Sampanna Pani. Ma'am is working as a partner at Pani and Tripathi Law Offices, a contemporary law office firm based in New Delhi. So ma'am has completed her LLB from Law Center 1, Faculty of Law, DU, in the year 2016, following which she completed her LLM with a specialization in criminal law from National Law University, Bhopal, in the year 2017. She enrolled with the Bar Council of Delhi in 2017, and initially she started her practice in the areas of service laws related to the armed forces and matrimonial laws. Then thereafter in 2019, she switched to the field of banking and finance laws, focusing on the different aspects of the Tripathi Act 2002, RDB Act 1993, and IBC 2016. So in her 5 years of practice, she has worked extensively on pension-related cases, transfers and appointments in government departments, subsidy-related cases of National Horticulture Board, and also cases related to defaults in construction, finance loans, and statutory sale of immovable properties and under the Tripathi Act. So we welcome you, ma'am.
Thank you, Riddhi.
In turns, first, ma'am will be delivering a lecture, and if in case you will have any kind of queries, please feel free to type it out in the chat box. And if you have any query, you can also raise your hand and I will recognize you and then unmute you. Over to you, ma'am.
All right. Thanks, Riddhi. Riddhi just read out a really long introduction, which had no mention of me practicing anything in family law. But just to let you all know, I also practice on that side. This session is about drafting a petition for divorce by mutual consent. But before I formally begin, I'd like to know my audience. So if you can have a quick introduction, your names, which college, and what semester you're studying in. If we can have that. I think that's all right, Riddhi?
Yes, ma'am, definitely.
Okay.
Okay, so shall we
quickly
begin one by
yes,
one?
if people can just, yes, please.
All right. So Ankita Datta, please go ahead with your introduction.
Ma'am, this is Ankita Datta. I'm from Durgapur Institute of Legal Studies in 4th semester. Thank you.
Next is Surbhi.
My name is Sobi Singh. I am pursuing BA LLB from IMS Unison University and I am in 5th year.
Prabnoor.
Good morning, ma'am. Myself, Prabnu Kaur from St. Soldier Law College, London. I am in 1st year, 2nd semester. Thank you.
Next is Sita.
Hi, ma'am. Good morning. My name is Sita. I'm pursuing BA LLB, 4th year, 8th semester. Thank you.
Arva.
Hello, ma'am. I'm Arva Bhutwala from Pune. I am pursuing BA LLB from DS Navalmal Firodia Law College. I'm in my 1st semester. Thank you.
Arushi.
Good morning, ma'am. My name is Arushi Chopra and I'm currently pursuing BCom LLB from Punjab University, 2nd semester. Thank you.
Hariyash.
Good morning, ma'am. My name is Hariyash. I am pursuing LLB TYC in St. Soldier Law College, London in 2nd semester. Thank you.
Navdeep.
My name is Navdeep. I am from Jalandhar and I am in 1st year of LLB.
Mayank.
Hello, ma'am. It's Mayank this side, and I'm in 2nd semester of 3-year LLB program from IMT College of Law, Noida.
Divya.
Hi ma'am, good morning. My name is Divya. I'm pursuing BA LLB 8th semester. Thank you.
Harshini,
I'm from Mitchell Law School, pursuing BBA LLB, currently in 6th semester.
Jayansh,
My name is Jayansh Sharma and I am from Manipal University, Jaipur, currently in my second year, 4th semester. Thank you.
Garima,
Hello, ma'am. This is Garima Sharma. I'm pursuing BLS LLB from KS Law College, Mumbai, and I'm currently in my first semester.
Nikhila,
Good morning, ma'am. I'm Nikhila Naidu. I'm from Hyderabad, ICFI Law School, Hyderabad, and I'm in my 6th semester.
Soham,
Good morning, ma'am. This is Soham. I'm doing my BBA LLB 6th semester in
I think she is facing some network issues.
Yeah.
Tisha,
Good morning, ma'am. I'm Disha Gupta and I'm from Indore, and I'm currently in second semester from Prestige Institute of Management and Research, Indore.
Guna, Guna, are you there? Okay. Anybody else I left out? Ma'am, I think we're done with the introduction.
Okay, thank you, everyone. It's good to have short introduction from everyone. Quite a large number of ladies in this group. It's nice to see that. Okay, so we'll begin with our lecture. I'll try to keep it short. This is the petition bit of it is really short. So I'll try to give you a brief and a background and also touch upon the general principles of drafting that you can use otherwise also in other drafts. Those of you who are in your 4th year, 5th year, or last semester, I expect some interaction from you guys. And I'm also assuming that you would have read the laws. So if you have your bare rights, please keep them ready. We'll be reading out the sections just to understand what are the elements involved in drafting the petition. Now, I'm going to try and share my screen. Please let me know if it is visible to you. Right. I hope you're able to view my screen.
Yes, ma'am, it's visible.
Okay, let's begin. What do you understand by a petition for divorce by mutual consent? I'd like to hear some answers. This is a fairly simple phrase, plain language.
Both the parties want the divorce.
Yes, yes. And anybody else? Both parties want divorce.
Applying to court for divorce.
Sorry?
Applying to court for divorce.
Applying to court for divorce.
Petition.
Right. Yes. But I mean, those are fairly easy guesses. You have to go to the court for a divorce, and both parties want it. But let's concentrate on the word or the phrase mutual consent. What does that mean? What do you understand by mutual consent? And can you think of an opposite to where there is no mutual consent? What happens there? Any guesses? Very simple. You're on the right track. It is what you've said. You approach the court, both the parties want divorce. Okay, I'll move on to the other side. Divorce by mutual consent means where husband and wife mutually agree to sever their marital relation and jointly approach the court seeking a decree of divorce. Now, what we need to remember here is that both parties mutually agree between themselves and collectively approach the court seeking a decree of divorce. What's also, I mean, this seems fairly simple to understand, but what's also important is that this consent should be present throughout the proceedings. And at any point of time or at any stage, if this consent or this agreement is withdrawn by either of the parties, such a petition is not maintainable. Right? So consent and agreement between the husband and the wife are the foundation of a petition for divorce by mutual consent. And consent must be continuous and present till the final disposal of the petition. Right? Now let's look at some of the statutes that contain these provisions for divorce by mutual consent. Before I show you what are those statutes, can anyone make a wild guess what could be the possible statutes? Or if you've read them, can you tell me a few statutes, few acts where such a provision is present? I'm assuming 4th years, 5th years have already read Hindu law, Special Marriages Act, Muslim laws.
Interns, please be interactive.
Okay, give me the obvious guesses at least, the ones that we know very commonly.
Madam, Section 13 of Hindu Marriage Act and Section 25 of Special Marriage Act.
Yes, that's right. Section 13B, that's correct, of the Hindu Marriages Act. Thank you, Natiti. And Section 28 of the Special Marriages Act. Go back to the slide. Anyone else who wants to add to this? Any other
And Section
provisions?
10A of Divorce Act.
Did you just Google that? That's a smart thing to do. So next time you will remember. Yes, Section 10A of the Divorce Act. That's correct. Can anyone tell me to whom the Divorce Act applies? You have 2 minutes to Google it. Why do we have special laws for everyone else, and why is there an Indian Divorce Act? Whom does it apply to? So, you just open the act, go back to the act, read off and tell me. It's all right. These are not very commonly used sections. But go back to the act and let's look at. Or in the meantime, if somebody else can also join in. Okay, the Divorce Act is applicable to Christians. So, for Christians, when they want to seek a divorce, it's under the Indian Divorce Act. Right. This is Section 2, which says applicability, talks about the applicability of the Act. Okay, I'll expect you guys to be interactive, otherwise it will become a very boring lecture. I don't have so much content, so please interact. I'll go back to the. Yeah, is my screen visible?
Yes, ma'am.
Okay. So statutes that contain provisions for divorce by mutual consent. Special Marriages Act 1954. The Divorce Act 1869. Parsi Marriage and Divorce Act 1936. And the Hindu Marriage Act 1955. Now, you look at all of these acts, and can someone tell me what is missing in this list? What is not covered in this list?
Muslim.
That's correct, absolutely. So the Muslim Marriage Act as such doesn't, there is no act, there is no Divorces Act. There are several acts which define the scope and the application of the Sharia law, but there is no codification as such of the Islamic laws. So the point that we need to remember here is that in all of these acts, the statute itself provides for divorce by mutual consent. It is the creation of the legislature. So this is something that is given to you as a statutory right. One can file for a divorce under these statutes. Now, what is the provision for Muslims? In contrast, now Muslim personal laws, as you must be already aware, or those of you who have not read it, they're largely based on interpretation of religious text and scriptures. They are not codified. So while we have different acts that apply to them, so what are the concepts, or how do divorce by mutual consent happen for Muslims? Now, there are two kinds of divorces under which the concept of mutual consent is recognized. One is khula and the other is mubarak. Now, those of you who have already read through family law, can anyone explain what khula and mubarak mean, and what is the difference between the two? Or if you've not read it, then please let me know that as well. I'm just assuming that you're in your final year, so you would have gone through these laws and you have a fair idea of what these mean. Anybody?
Ma'am, khula, the wife asked khula from the husband. Like
Yes,
a
that's correct.
request.
Who's this? I'm sorry, I don't know who's speaking.
Ankita Datta.
Okay, great, Ankita. Please go ahead. Yes, you were explaining, Ankita. Please, can you explain that again?
I think her network has stopped.
Oh, okay. All right. Anybody else would like to try? Come on, guys.
Ma'am, khula and mubarak are the special provision given to the Muslim women, and rest of the provision are given to the men only. In khula, the woman can demand a divorce from the husband, and in mubarak, they mutually consent to have a divorce.
Right. Sorry, I don't know who this is.
Ma'am, Navdeep.
Navdeep. Okay, Navdeep ji, thank you for that. Navdeep, little bit of correction here. In khula, as you rightly pointed out, the wife seeks or proposes divorce, and this is in lieu of property, dower, or compensation. Basically, she proposes that she is seeking a divorce, and in order for her to convince the husband, she gives up either her dower. Dower is basically all your whatever money, property, gifts, whatever she's received at the time of marriage, or property. There is a joint property here, or give some amount of compensation for the husband to accept the proposal. Once this is accepted, the both parties then mutually agree to get a divorce. This is one method. Mubarak is, you said it is available to only women. Mubarak is available to both parties. It can be proposed by either the husband or the wife. Either one of them can say, we don't wish to live together, we wish to live separately. And this happens without any compensation or without either of the parties giving up any of their rights on any compensation or seeking any compensation. And both one proposes, the other agrees, and both of them mutually agree that they want to go ahead for a divorce. Now, what happens when two parties agree like this? How do you give it sanctity under law, considering that there is no codification? So, how do they, suppose they agree, and how do they sort of get it legalized or sanctified that yes, they are divorce parties? Any clue on that? Anybody? You're allowed to Google also. At least you'll read up.
Ma'am, in the presence of the witness.
Okay, that's what you're saying is right, that there needs to be a witness, but do they have to go to court also? or can they just declare it between themselves and go about their business as usual? Take a guess. You don't have to give the right answer also.
Yes, ma'am. They also have this option. They can move
Yes,
to
and
the
how?
court.
All right. Who's this?
Ankita Datta.
Ankita, right. I'm sorry. I am not able to see you guys once I share my screen. Right. So, Ankita, you said this option is also available. Do you have any clue of how that procedure works? Or
No, ma'am.
how do they approach the court? Okay. So, what
They
I'm
just
referring to
hire
here is
a
the.
lawyer, I think.
Yes, that's a smart answer. They have to hire a lawyer. But so basically, what happens is they have to get a declaration from court, which happens under Section 2 of the Muslim Personal Law, Shariat Application Act 1957. Both the parties approach the court saying that they wish to be mutually divorced, and which they have done by either say Khula method or by Mubarak, and they get a declaration under Section 2 of the Muslim Personal Law Application Act 1957. This was recently done in a case. This is by the Honorable Bombay High Court. Anyone who's a subscriber to Live Law would probably know this. Any guesses? Very recent judgment, I think, came 4-5 days back, where the court reiterated that yes, mutual consent, a divorce by mutual consent is available even to Muslims. Anyone like to guess? Okay, it was Sheikh Taslim Sheikh Hakim versus State of Maharashtra and another. It was a criminal application. In this, the parties had already consented to seek mutual divorce, also pronounced divorce, and they sought a clarification and a declaration to that effect from the court. You will find a lot of cases on this. There are a lot of judgments by the Honorable Supreme Court as well, but this one is the latest one. Okay. Now, provision of divorce by mutual consent under the Hindu Marriage Act 1955. So I'll be specifically talking about this because this is the most commonly filed petition under the Hindu Marriages Act, and it is identical to the provision contained under the Special Marriages Act and the Indian Divorce Act. The elements are more or less the same with few technicalities here and there. Now, I've just added the provisions here. I'd like one of you to please read it and voluntarily read it. Please read subsection 1 and then somebody else can read subsection 2. Or if you don't want to read from my screen, then you can also refer to your bare eyes. One of you, come on. You just have to read it, nothing else.
Ankita, you go ahead.
Ma'am, what I have to read exactly? Statutes?
Yes, can you read my screen?
Yes, ma'am.
Yes, so you see section 13B, divorce by mutual consent. Can you read subsection 1?
Ma'am,
No, I
actually, your
see
screen
that.
shows the statutes that contain provisions. It's
Yes,
not showing
ma'am.
the provisions actually.
Oh, okay, that's strange. Back. Okay, is it visible now?
Yes, ma'am, it's visible now.
Okay. Now can somebody read it?
Provision of DBMC under the Hindu Marriage Act 1955 Section 13B, divorce by mutual consent. Subject to the provisions of this Act, a petition of dissolution of marriage by a decree of divorce may be presented to the district court by both the parties to a marriage together, whether such marriage was solemnized before or after the commencement of the marriage laws, Amendment Act 1976, 68 of 1976, on the grounds that they have been living separately for a period of 1 year or more, that they have not been able to live together, and that they have been mutually agreed that the marriage should be dissolved.
Great, thank you. Can someone just highlight the key points? They're already in bold. So what are the key elements? Okay, key elements. Petition for dissolution of marriage by a decree of divorce may be presented to a district court. So that's number one. It has to go to the district court. Two is that both the parties to a marriage together have to approach the court. Three is this is applicable retrospectively as well as prospectively, which means before or after the commencement of this act. 1976 Amendment Act 68 of 1976. This is basically the Amendment Act which was brought in 76, and this section, which was not originally there in the Act of 55, was inserted by the amendment of 1976. So curiously, all other statutes originally had the provision for divorce by mutual consent, except for the Hindu Marriage Act. And in the Hindu Marriage Act, the provision was added in 76. So three elements we saw. It has to go to the district court. Both the parties have to mutually approach the court, and this applies retrospectively as well as prospectively. Fourth, and the most important, is they have been living separately for a period of 1 year or more. So where parties have not been living separately for a period of 1 year or more, a petition for dissolution of marriage by mutual consent is not maintainable. The fifth element is they've not been able to live together, and they've mutually agreed that marriage should be dissolved. So this is basically a reasoning. It's not enough that you've just been living separately. They have to also, the petitioners or the parties approaching the court have to also submit and show to the court that they are not able to live together anymore, and they have mutually agreed that the marriage should be dissolved. Right? I hope I'm clear. Can somebody read the second subsection? Subsection 2. There's so many people here. Harshini,
Please go ahead.
Jayansh, Garima, Nikita, anybody?
On the motion of both the parties made not earlier than 6 months after the date of the presentation of the petition referred to in the subsection 1, and not later than 18 months after the said date, if the petition is not withdrawn in the meantime, the court shall not be satisfied, after hearing the parties and after making such inquiry as it thinks fit, that a marriage has been solemnized and that the avermats in the petition are true, pass a decree of divorce declaring the marriage to be dissolved with effect from the date of the decree.
Wonderful. Anyone would like to highlight the key points or what they've understood, or any confusion also for that?
Ankita, Sneha, please read the key points.
Made not earlier than 6 months after the date. Second
That's
one
right.
is and not later than 18 months. Third one is
Right.
if the
So
petition is not withdrawn in the meantime, the court shall on being satisfied.
Right. What do we mean by not earlier than 6 months and not later than 18 months? What does this mean? Anyone who's done a court internship or who's worked under an advocate and watched the proceedings? Okay, basically what happens by when you file a divorce by mutual consent, so if the parties qualify and meet the conditions mentioned in subsection 1, then the first motion petition is filed. Now, anyone who's gone to court, or if you've not gone to court, when you go, you will watch the proceedings. The first petition that has to go is the first motion petition, which needs to fulfill and satisfy the conditions mentioned in subsection 1. Once the court hears your petition, your first motion petition, and is satisfied that all the elements are met, it gives you a date of 6 months. Right? Why is that 6 months granted? Anyone like to take a wild guess?
Like if they anyhow they change their mind.
Absolutely, that's correct. Who am I speaking to?
Ankita Datta.
Hi, Ankita. I'm sorry, I keep asking your name.
That's fine, ma'am.
Right. So, okay. So if the parties decide that they want to reconcile, if they want to withdraw the petition, or if they have settled their disputes, then they may withdraw it or simply let the petition lapse. That is not approach in the second motion. Therefore, a time period of 6 months is granted. That's the minimum time period that's given. It's also known as the cool-off period. So the parties have time to either go for mediation, talk to the family members, reconsider their decision, so on and so forth. But this time period of 6 months is also not mandatory. It is a guideline, it is statutorily provided. But in exceptional cases where the parties are able to show that there is no chance of reconciliation happening, then this period of 6 months may also be waived off. And a petition can be filed before the expiry of 6 months. Now, subsection 2 says, on the motion of both the parties made not earlier than 6 months after the date of presentation of the petition and not later than 18 months. So basically the timeline is that you approach the court not before 6 months, but not later than 18 months from the date of filing of the first motion petition. So in the meantime, a second motion petition is filed. And if on the second motion being filed, the court is satisfied after inquiries from the party, basically they ask that, are you doing this under pressure, or is this a collusive petition, or are there some dues due to which you're filing this petition? If on doing these inquiries and being satisfied that parties actually are seeking the divorce, the court will then pronounce divorce and dissolve the marriage. The effective date of resolution of the marriage is when the order for second motion petition is passed. So basically, it takes roughly about, say, a year's time for the marriage to be resolved. Or in cases where there is a waiver, it can happen also in 6 months. Right. Okay, key elements. Has the screen switched for you guys, or are you seeing the previous slide itself?
Ma'am, it's showing provisions of BBMC under the Hindu Marriage Act.
It's very strange. Okay, I'm sorry for this.
Yes, ma'am, it's visible now.
It's visible now? Okay. So key elements. This is a recap of what we just discussed. Preconditions. You're able to read my screen?
Yes, ma'am.
Okay, great. Petition to be presented by both parties together. Should be living separately for 1 year or more. Mutually agree to dissolve the marriage. Where all the 3 preconditions are fulfilled, a petition for divorce by mutual consent may be filed. Such petition fulfilling all the preconditions is called a first motion petition. Right? Now, these are the preconditions. So basically, preconditions are mentioned in 13B, clause 1. Now, what are the procedural conditions? These are the ones that are mentioned in 13B, subclause 2. The first is after 6 months, but before expiry of 18 months from the date of order of the first motion, the second motion petition will be filed. Number 2 is that 6 months period is not mandatory. An application may be filed for waiving of the cool-off period. 3 is on the satisfaction of the court. A decree of divorce may be passed, dissolving the marriage, effective from the date of the decree. This decree is after the second motion petition. Now let's okay. Yes, now on to the topic, drafting a petition for divorce by mutual consent. Till this point, anyone has any doubts? There's clarification.
दोनों के सामने तो सारे को डिवोर्स अच्छी बात चीज नहीं है समझ लो
Shall we proceed? Or anyone wants to ask anything?
Ma'am, you may proceed ahead.
Okay, drafting a petition for divorce by mutual consent. Now, let's look at some general principles of drafting. Anyone who has had any internship experience before, what are usually the general principles of drafting? Key points to remember. Volunteers would like to say anything? Yes, Shubham, Arushi, Mayank, Divya, Subhi, anybody? What are the general principles of drafting? Has anyone had any experience of going to court or assisting an advocate in courts? This one-way lecture is going to be very difficult. Shubham, would you like to say anything? See, your mic is on. Okay, I'll go back to sharing my screen. General principles of drafting. I hope this is visible to you guys.
Yes, ma'am.
Number one is your cause title. Thanks, Liti. Okay, so number one is the cause title. What is the cause title? Cause title is the name of the parties who are approaching the court. Why is that important? That's important because that defines the rest of your case. Who is suing whom, or who is appealing to the court against the other? That's number one. Number two is jurisdiction. Jurisdiction is which court you're going to approach for the relief that you're seeking. Does it have to be the district court or the high court or a tribunal or a quasi-judicial body or an arbitrator? What is the jurisdiction? Next is your provision or provisions of law. This includes your jurisdiction. How are you invoking the jurisdiction? Jurisdiction is basically the power of the court. Under which provision are you approaching the court for the relief that you're seeking? And what is the provision applicable to the grievance that for which you are seeking relief from the court? Those are the provisions of law. This also includes limitations of fees, so on and so forth. But basically, the main point is that why you're approaching a particular court. Next two are facts of the case that are essential, very basic. Who are the parties? What is the dispute? And what is that they're seeking? Sixth is, of course, your grievance, the reason for filing a particular petition. Why relief should be granted or merits. So this is where you argue your case out and you submit before the court. This also, anyone who's done any court internship would know that after facts, we write something known as grounds. So your grounds are reasons which you give to the court that why relief should be given to you, or what are the merits of your case. And lastly, but most importantly, prayer or relief sought. What is it that you want the court to do? What is the and whether that is possible under the law, whether the court that you're approaching has that jurisdiction, that power. That is the prayer or your relief. Right. Now, let's apply this to a draft of divorce by mutual consent. Has the slide changed for you guys?
Yes,
Yes,
ma'am.
ma'am.
Yes, ma'am.
Okay, great. Thank you. So all the 7 elements. Now, first is cause title, names of the parties. Now, in a petition for divorce by mutual consent, what is most important to remember is that both the parties are approaching the court together. So, therefore, they are both petitioners. Nobody is a respondent in a petition like this. So, if it is husband and wife, so husband becomes petitioner number 1 and wife becomes petitioner number 2. Because they are jointly approaching the court, there is no respondent. Otherwise, in all of the cases, one party sues the another. The person who is suing is the petitioner or the plaintiff, or in cases of appeal, an appellant. And the other party, which is being sued, is your respondent or defendant, depending on whether it is a suit or a petition or an application. So that's the first thing that you need to remember. Now, second is your jurisdiction. Now, I've just culled out usually like all of these acts, SMA, Hindu Marriage Act, your Divorce Act, they have general principles on where these petitions can be filed. So all of these petitions have to be filed in the district court, but which district court? So some of the common arrangements are where the parties last resided, so where both the parties live together as husband and wife. Suppose one party is from Indore, the other is from Agra, they live together in Delhi, so they can file it in Delhi because they last resided there. Where the marriage was solemnized, suppose it was solemnized in a third place from where they're not belong, they can file it even there. I think someone's mic is on and there is some construction work happening in the background. If you can just mute yourself. Right. The third is where one of the parties presently reside. Usually what also happens is that for the convenience of the wife, the place of filing such a petition is usually where the wife resides. Or it can be also the husband if the parties mutually agree. Now, provision of law. So under the Hindu Marriage Act, we have section 13B, which expressly provides for divorce by mutual consent. Under the Special Marriages Act, it is section 28. Indian Divorce Act, it is section 10A. And Parsi Marriage and Divorce Act, it's section 52. So these provisions expressly provide for divorce by mutual consent. And one needs to satisfy the elements of the provision, like how we saw in the previous slides, that what are the key elements. So one petition needs to cover all of those key elements. Fourth is your facts. So first you mention the basic details such as your name, father's name, husband's name, place of address, age, what was the age at the time of the marriage, what is the present age, what do they do, these kind of basic details. Second is relevant facts related to the marriage. This is important. So basically, why this is important is so that you also tie your jurisdiction with the facts. So facts that are related to marriage, basically the date of the marriage, where it happened, how it was solemnized, whether it was registered or not registered, whether there is any child of the wedlock, out of the wedlock or not, or whatever, any exchange of gifts or anything which was done, these kind of facts. Third is your background to failure of marriage. Basically, you give the reasoning as to why the marriage has not worked and why the parties are seeking for a dissolution of the marriage. Right? And it can be usually in a petition for mutual divorce. What happens is the parties don't blame each other of any specific, wrongdoings. And usually the language is that parties are unable to live together or that they don't think the marriage is working and they've tried all possible reconciliation methods and it's not working. And there is no blaming or calling out of specific wrongdoing. So a background to the failure of the marriage. Fifth is your grievance. So in a petition for divorce, it will be dissolution of marriage. So what are you seeking? You're seeking dissolution. In sometimes like you have property disputes, so you seek injunction or declaration. or when you file writs, so the writ of certiorari or mandamus or habeas corpus, or what is the grievance, what are you seeking? Sixth is the merits. Why should the court entertain your petition and why the relief that you're seeking should be granted? So those are the merits of the case. So in this case, what are the merits? Number one is that there is mutual consent between the parties. Whenever you file a petition, you also file an affidavit and you write the same contents that you mentioned in the petition in that affidavit. You swear and you basically file before the court saying that, yes, this is my, I give my consent to filing for this petition and I give it till the final dissolution of the marriage, passing of the final decree. And that I'm not doing this under pressure or under coercion or any force or fraud. Right? So there is mutual consent between the parties. Second is that the parties are approaching the court together. So it is not as if one has dragged the other to court. Both of them wish to dissolve the marriage, and that's why they're mutually approaching the court. Third is that they have they've lived separately for more than 1 year. Now, this is a precondition that we saw mentioned in section 13b(1). This is a technical sort of a requirement, and the parties say that we meet this requirement, and therefore a decree of divorce by mutual consent should be passed. Now, your last principle is prayer. So here it is obviously seeking a prayer for divorce. So both the parties agree that yes, they don't want to continue with the marriage, and hence a decree of divorce be passed. Right? And that's the end of it. That's the end of my slideshow. Now we're open for questions, if any.
Can you please tell the cool-off period? You have said that the cool-off period is of 6 months. Sir. So before
right.
6 months, we can't apply for the second petition.
You can apply. So, like I said, this is not a mandatory requirement. It is a guideline. It is basically given by the court so that the parties have time to, reconsider their decision. Why this cool-off period is also given is important. Now, if you go back and read your Family Courts Act, that says that the institution of marriage and the family as a system should be protected, which is why the cool-off period is given. However, it is not mandatory for everyone to go through that period of 6 months. Suppose in a case where parties have been living separately, so say 3 years, or there is an agreement which has happened between the parties, a mutual agreement of sorts, that they want to call it off and that they will file for an application for waiver of the 6 months. In that case, you can approach the court even before the expiry of 6 months. So what you can do is you can come, say, after a month or two and say that, we don't require this. We've already reconsidered and we're just seeking that a final decree be passed. So that's, I hope I.
Okay, ma'am. Thanks.
Yeah. Okay. Anyone else?
Ma'am, during the drafting, do we have to give the titles like you have discussed the case title, jurisdiction, provision of law? Do we have to give the titles in our drafting?
Yes, absolutely. Absolutely. So your case title is basically what defines your petition. It identifies it, and your decree is passed basis that case title. So whenever your case is basically under what names the petition is being filed. So cause title is what you give. Case number is what is given by the court. So those cause titles are important, and you have to mention it. A lot of times courts will not entertain a petition if they fail to mention correct cause titles or don't give the right jurisdiction. So those are key elements. Anybody else?
Ma'am, is it possible that if we file for a mutual divorce, the court can grant for judicial separation?
Absolutely, the court thinks so. In fact, there is a provision also. Great that you brought this up. 38A talks about alternate relief in divorce proceedings. So that squarely covers your question. In such petitions, the court always tries that parties reconcile. But if they are not able to reconcile, then the court can also pass a different decree. So a lot of times what also happens is that before filing for a divorce by mutual consent, one of the parties would have filed a petition for restitution of conjugal rights. That's Section 9 under Hindu Marriages Act. Or a petition for judicial separation. What judicial separation does is that you're still married, but you're not required to live together. So the parties seek that, please allow us to live separately. We don't want to fulfill our marital duties towards each other. We don't want to have any other claims. So even in a petition for a divorce by mutual consent, such relief can be granted if the court thinks fit. And usually these kind of orders are also passed where children are involved. If the court thinks that it is better for the the education, or future, or the progress of the child, such an order may also be passed.
Okay.
Anyone else? Any other questions?
You can even type out in the chat box.
Ma'am, do we have to write the case laws that previously decided in the High Court or Supreme Court and relevant to our mutual consent case divorce?
No, not in a petition for mutual consent, because mutual consent is largely based on your facts and meeting the elements mentioned in Section 13B. You may have to quote those provisions when you're filing for an application for waiver of those 6 months. There you have to cite a law, because the statute itself requires that you cannot file a petition before expiry of 6 months. So there, when you make an application for waiver of 6 months, you say previously in XYZ case passed by the Honorable Supreme Court or High Court, the court has granted such a relief. So this may also be granted to me. It is applicable to me. But in your main petition, you don't have to mention any case laws. It is a provision that is available to all. As long as you satisfy the elements, it's good to go. So just mention the facts, the grounds, and your prayer. No need to mention the judgments.
And if there is a case that both the parties are living separately for 1 year, more than 1 year, but they are not mutually agree for divorce, that husband will agree and wife is not agree. So what will happen?
So then they cannot file it. As simple as that. You cannot force the parties. See, there is only husband and wife can seek divorce. Nobody can seek it on their behalf. And they have to come together. So when you go to courts, you will see that a petition for divorce has to be countersigned by both parties. So you basically sign on the same page. If they don't sign it, then such a petition is not made. It cannot be filed. The precondition is that they have to both agree and say on an affidavit, say in a petition that both of them want this, both of them are in agreement, and they mutually want to resolve the marriage. So it's a precondition that there should be agreement between the parties. Otherwise, such a petition cannot be filed. In that case, one party can file for a divorce and it then becomes a contested divorce, which is the opposite of the divorce by mutual consent.
Yeah, thanks.
Anyone else is having any doubts? Okay, seems like there are no further doubts. So I'll proceed with the vote of thanks. On behalf of Team Law Internships, I would like to thank you, ma'am, for coming here and training our interns so well. The session was really wonderful and interesting one. So I hope the interns, you have enjoyed this session and you are taking something from it. Thank you so much, ma'am. Thank you for joining.
Thank you, Riti. Thanks, everyone. This is a great session.
Thank you, ma'am.
Thank you, ma'am. Thank you.
Bye-bye.
Thank you, ma'am.
Bye-bye.